I am pleased to welcome Professor Adam Pritchard from University of Michigan Law School and Case Western Law's own Eric Chafee, who attendees will recognize as a longtime friend of the conference. They're here to talk to us about securities law at the U.S. Supreme Court and update us on what's been going on. Professors?
So I don't know how much updating I'm going to be doing. I'm going to take you back a little bit. I'm going to talk about a book that Bob Thompson and I recently published that unpacks the history of securities law in the Supreme Court. This is an audience that probably doesn't have to have too much hype to get you interested in securities law. At least I hope not. But I'm hoping I can persuade you that looking at a particular slice of the Supreme Court's docket that can give you some insight into how the Supreme Court works as an institution and the influence of the individual personalities of the justices on the development of the law. So I'm going to give you an overview of that history with a few examples from the development of insider trading law, which I think kind of illustrate pretty well some of the trends that Bob and I uncovered in the course of writing this book. So I have read every securities law case the Supreme Court has ever decided, and we have, my co-author and I have gone through the files of the justices, which are located in the Library of Congress and various academic institutions across the country, Kentucky, Princeton, Yale. We've been there to see them. We went through the files. We copied interesting stuff. For some of the newer cases that we looked at, I was lucky enough to be able to talk to some of the clerks who worked on the cases. So they were very helpful in fleshing out the opinions, the paths of the opinions. So as we see it, the first 85 years of securities law in the Supreme Court can be broken down into about a half dozen periods that have trends, recognizable trends to them. So securities law is first enacted starting in 1933. When the first case gets to the Supreme Court, there's some initial hostility from the old guard. That quickly changed when the new justices that Roosevelt appointed came to the court, and the court quickly, enthusiastically embraced the new laws and showed a great deal of deference to the SEC. After the war, securities law became something of a backwater, mainly because the SEC became a regulatory backwater during the late 40s and 1950s. Budget was recurringly cut, and there just wasn't much going on in the field of securities laws. Starting in the 1960s with the Warren Court, we see some new life in the area of securities law in the Supreme Court, and I'll talk about the activist approach to the securities laws that the Supreme Court adopted then. That comes to an end in 1972, period that we call the counter-revolution, a 15-year period where the SEC's long winning streak in the Supreme Court came to an abrupt halt, and even in a reverse. And then the last period is from 1988 to today, which the court is in relative equipoise when it comes to securities cases. The deference to the SEC and the skepticism of the SEC that we saw in the earlier periods now kind of show up in equal measure. There's not a real clear direction in the cases. I'm going to touch on that. Eric will have more to say about the Roberts Court and its role in securities law. I like the musty old stuff. Eric's a cutting-edge guy. So the initial hostility. The Securities Act is passed in 33. The Exchange Act is passed in 34. And as I'm sure you will all remember, the Public Utilities Holding Company Act, which is easily the most controversial and hotly contested securities law of the 1930s is passed in 1935. And it's that last one, the Public Utilities Holding Company Act, PUCA to its friends, that raised the most serious constitutional concerns. And so Black Monday, major event in Supreme Court history when the Supreme Court rebuffed Roosevelt's attempts to regulate the economy through the National Recovery Act, which led to a coalition of the conservative justices, and even Louis Brandeis, known progressive, objected to the centralization that was going on in the Roosevelt administration. And Brandeis, after Black Monday and the cases striking down the National Recovery Act, takes Roosevelt's henchman, Tommy the Corcoran, into the cloakroom at the Supreme Court, where the justices put on the robes, and sends him, gives him a message to take back to the White House and share with President Roosevelt that this is the end of the centralization. It's coming to an end. And so at this point, if you are a lawyer at the Justice Department in the Office of the Solicitor General, you're not excited about your prospects of defending the Public Utility Holding Company Act in the Supreme Court. And the first case involving the federal securities laws to come to the Supreme Court is SEC versus Jones. And this is George Sutherland, who writes the majority opinion. I would say he was the intellectual force of the old guard, educated at the University of Michigan, I will note. And he compared the SEC and the procedures it was using in a stop order proceeding as the equivalent of the infamous Star Chamber in Middle era England. So this definitely gave the Office of the Solicitor General some pause. So this is 1937 that the court is rebuffing the securities laws with the initial foray. And now the Justice Department is playing for time. They're trying to get the constitutional challenges to PUCA stayed. Why time? Well, they want a better court. And a better court was forthcoming. You're familiar with the switch in time that saved 9 and the court packing plan. But the real impetus was pensions. Congress had cut the pensions of justices who retired in the early 30s as an economy move because the government fisc was not looking good circa 1932. And in 1937, Congress restored the pensions to the justices who retired. You get your salary for life as a federal judge, but only if you're working, sadly. But the pension was restored in 1937 for justices who retired, and it quickly led to a turnover of the personnel on the court. And the new justices pretty consistently had some involvement in the securities laws before they went on the court. So here's Hugo Black as the first of them. He was the Senate leader on PUCA and waged a fierce lobbying battle against the public utilities that had pulled out all the stops to stop the law. And Black was the leader in beating back the public utility press against PUCA. Stanley Reed was the Solicitor General during the time of the initial challenges to the securities laws. He's the architect of the waiting game where the Justice Department made every effort to delay the decisions on PUCA. And Felix Frankfurter helped craft that strategy of delay from his perch at the Harvard Law School. More notably, he had come down to Washington in 1933 with Jim Landis and Ben Cohen in tow to rewrite the Securities Act, which the relevant members of Congress had made a hash of. And Frankfurter was called down with two of his proteges to write a new statute, the Securities Act of 1933. And Frankfurter had also played an instrumental role in drafting PUCA. This guy, Bill Douglas, made it to the Supreme Court after a short stint as the chairman of the SEC, where he had taken on the New York Stock Exchange and the New York Stock Exchange's old guard. And Frank Murphy was the Attorney General during the defense of the constitutional challenges to the securities laws. Roosevelt was not a huge fan of Frank Murphy and kicked him upstairs to the Supreme Court to get him out of the Justice Department. Murphy, also a Michigan-educated lawyer. And my research indicates somewhere around a C+ student. So there's hope for some people who didn't light it up in law school. Jimmy Burns had helped engineer some of, as a senator from South Carolina, had helped engineer some of the statutes making their way through Congress. Bob Jackson, perhaps the most gifted advocate at the Justice Department in the 1930s, had worked hand in hand, both drafting PUCA and then in defending PUCA in the courts against the constitutional challenges. He was delegated to the SEC from Treasury to help argue those cases. And then the last one, and probably the least, is the law professor, Wiley Rutledge, who had written op-eds campaigning. As a corporate law professor, he had written op-eds campaigning for the adoption of the securities laws. So all of these justices in some way or another had fought for the securities laws prior to coming to the court. And for Franklin Roosevelt, at least in this area, it meant he had a reliable court, right? So the initiative to impose social control over finance was one of the great policy agendas of the New Deal and the Roosevelt administration. And from a jurisprudential standpoint, Roosevelt had great success with his appointments. If you contrast Warren and Brennan, appointed by Eisenhower, a lot less reliable. Why was Roosevelt so successful? So people had experience, right? They had been in the trenches in the Senate and in the courts. Roosevelt had a litmus test. All of the justices that I just showed you had either supported the court packing plan in the 1930s, or they had stayed silent despite great pressure to denounce the very unpopular court packing plan. None of them did. Bob Jackson and Bill Douglas sat in on the president's poker game at the White House during their time on the Supreme Court. A little more cozy in Washington than you'd expect to see today. And a number of them were very ambitious. Hugo Black and Bill Douglas certainly did not think that the Supreme Court was a destination job for them. They both aspired to be the vice presidential candidate in 1944. Tommy Corcoran was working to put Douglas into that spot. Unfortunately for Douglas, the party picked Harry Truman, and history was different as a result. It's kind of a wild bill in the White House. That scares me a little. This enthusiasm for the New Deal and the new securities laws did not mean necessarily a unanimous approach, and it didn't take too long before a split broke out in the Supreme Court, and it shows up most prominently in the Chenery case. So you might recall Chenery 1, standing for the administrative law proposition, still an important proposition that the agency has to sufficiently state the reasons for its actions. First brief I wrote as an appellate lawyer at the SEC, my boss, the most excellent and learned lawyer, Jake Stillman, had to call me into his office and ask me if I had ever read the Chenery decision because I had come up with a much more persuasive argument for what the commission had done. And Jake, while impressed with the quality of my reasoning, had to say, you don't get to make that stuff up. So Felix Frankfurter wrote Chenery 1, and his goal was not to thwart the administrative state. He very much believed in it, but he saw the administrative state as based on a delegation of authority from Congress to the administrative agencies, and he saw it to be the role of judges to keep the administrative agency to the statutes that enabled the administrative agency to regulate in the way that it did. And he thought the legitimacy of the administrative state depended on the adherence to the laws that Congress had passed. That would give democratic legitimacy to this independent agency. So that was Frankfurter's view. It did not ultimately prevail in even the Chenery case. The court strikes down what the SEC had done in the Chenery case. They had barred insiders in a public utility reorganization from participating in the ownership of the reorganized company because they had dealt in the company's securities during the reorganization proceeding. So this is the first glimmer of insider trading doctrine under the federal securities law in the Supreme Court. The SEC had said they couldn't participate. Frankfurter gave the SEC a lecture on fiduciary duty and the deficiencies in their reasoning, and they sent it back to the SEC to come up with some better reasoning. The SEC made a half-hearted effort, and the case comes back to the Supreme Court 4 years later. There's been some transition in the personnel, and now the much more progressive Hugo Black is writing the opinion and basically says the SEC can make the rules up as it goes along in the course of adjudication. So this is another bedrock principle from federal securities laws that persists to this day in administrative law. So this creates an opportunity for the SEC if there's an agency that wants to seize it. And Bill Carey is appointed chairman of the SEC by John Kennedy in 1961. And part of Bill Carey's vision for what the SEC should be doing is a campaign against insider trading, right? And so federal securities laws had really not spoken to insider trading prior to Bill Carey's arrival. He writes the very famous Katie Roberts decision in an administrative proceeding, sets out a standard, access to corporate info, unfairness in using that information. That's a great standard. I understand it. That's a convincing principle. It has nothing to ground it in the text of Section 10b or Rule 10b-5 of the Exchange Act. This was Bill Carey freelancing. And the question was, could it get away with it? Would it survive scrutiny in the Supreme Court? And so Bill Carey's timing is good because new blood is coming to the Supreme Court. It's kind of fun to call these guys the new blood. They look like old white men to me. But that's Arthur Goldberg and Byron Wizard White, who were both appointed in the early 60s to the Supreme Court. And Arthur Goldberg was very much in the activist mode of federal judges. He saw his job as to get some things done. And wanted to push an activist policy, and White was right there with him. And so the insider trading revolution in federal securities laws in the Supreme Court begins with the capital gains case. And the court announced a fiduciary duty basis, that if you had a fiduciary duty to the person on the other side of the transaction, there would be a duty to volunteer material information, that fraud would not be limited to just affirmative misstatements. And this was a revolution in the law of deceit and a revolution in the development of the securities laws. And so the Second Circuit, which had taken a very narrow position in the capital gains case when it was at the Court of Appeals level, was reversed in capital gains, and they got the message. In 1968, Texas Gulf Sulphur case comes to to the Second Circuit, and they adopt a very broad principle, at least as broad as the principle that Bill Perry had adopted in K.D. Roberts, sometimes called parity of information, equal access to information, but a very broad construction of Section 10b and Rule 10b-5. And that's where the law was evolving in the 1960s based on capital gains. Another important case from the Supreme Court in the 60s was the J.I. case versus Borak, where the Supreme Court, opinion by Justice Clark, said that they were going to make up private rights of action even when they hadn't been created by Congress. And those two trends together, a broader vision of fiduciary duty, the creation of private rights of action, were perceived as creating the basis for a federal corporate law to correct the deficiencies in state corporate law. It looked like federal law might take over the field of corporate and securities law and become a unified federal body of law. Nope. 1972, Richard Nixon appoints Bill Rehnquist, and much more importantly for our story, Lewis Powell to the Supreme Court. And Lewis Powell was the president of the American Bar Administration, and he'd come to the attention of Richard Nixon by giving some speeches about the Warren Court going too far in the field of criminal procedure and favoring the rights of criminal defendants too much. And Richard Nixon had run on a law and order platform and against the Supreme Court to some extent. And Lewis Powell was appointed to the Supreme Court to help bring around some law and order. But what Lewis Powell knew was securities law. So our corporate lawyer is a quote from Harry Blackmun when he was in the minority in yet another case that he had lost in conference that Lewis Powell had swung the majority. Blackmun wrote this in his notes from the conference in that case. And Powell had been a corporate securities lawyer in Richmond from the 1930s up until his appointment to the Supreme Court. And he had a favorable view of the securities laws, but a pretty skeptical view of the SEC. And when Powell comes to the court, it's a new cast on the Supreme Court. We have Powell, who is a lifelong corporate lawyer, an expert on securities laws, and 8 other guys who don't really know much about securities law and don't really care that much. And the combination of Powell and his expertise and a very keen interest in the field of securities laws, he worked much harder on these cases than his colleagues did. He would come to the conference where they would take the vote to decide the securities cases with a memo, with a full analysis of the case and what the important legal issues were and how he thought they should be resolved. And the other 8 justices are just kind of showing up to vote. And in 41 cases decided by the Supreme Court in securities law during Justice Powell's tenure on the court, he was in the majority in 40 of those cases. He dissented 1 time. And he wrote 11 of the 40 majority opinions that he was a part of. So he had a very outsized influence over federal securities law. And insider trading is a great illustration of Powell's influence. He wrote the opinions in both Chiarella and Dirks. The Supreme Court had been writing more textualist opinions in the field of securities laws under Powell's influence. But here in the field of insider trading, there was not really any text to work with. So Powell developed his own common law of insider trading, broader than the historical prohibition against deceit, which didn't really cover exchange trading. Powell did extend the prohibition against insider trading to exchanges, but he grounded it very much in a duty to disclose between the parties to the transaction, and not the much more expansive view that the Second Circuit had endorsed. And so he took the fiduciary duty analysis from capital gains and confined it to more familiar territory within the common law of deceit. And then Powell retires in 1987. There is some kerfuffle about replacing him. It takes some time, but eventually he's replaced by Tony Kennedy. And we see the misappropriation theory, insider trading, comes back to the Supreme Court with the O'Hagan case. And when I said earlier, the court goes back and forth. Well, here we've got a lawyer who's stealing information from his client and trading on it. And the majority of the Supreme Court is pretty sure that this crooked lawyer should be going to jail. And the Justice Department and the SEC win the case. And I'm very pleased to say that the O'Hagan opinion is a pretty close paraphrase of the government's brief in the O'Hagan case, which I might or might not have played some role in writing. But child Justice Ginsburg. Marley, that's what I gotta say. Okay, the SEC, tinkering around the edges in the law of insider trading. What does the Supreme Court do when they come back to insider trading? The Salmon case? Nothing at all. They don't know which cases to take. They don't have Powell guiding them in Salmon. They have an important insider trading issue, they think. And the decision says, read that Dirks opinion, because that resolves this case, and we still believe in Dirks. So not much happening because the justices are not great at picking the cases. And so some shifts in Supreme Court jurisprudence, hostility to the New Deal early, the triumph of the administrative state in the 1940s, a very progressive Warren Court expanding the securities laws even without amendment from Congress, and then strict constructionism. In the securities laws, at least, the views pushed by Richard Nixon on the campaign trail prevailed. And then after the departure of Powell, the random walk. So just to show you, I'm not making that up. You see Supreme Court very expansive interpretations through 1972. That trend flips from 1972 to 87 while Powell is on the court. And then half expansive, half restrictive. A lot of deference to Congress. If there's any congressional action in the area, the court is happy to say that that resolves the matter. This is my brief foray into the future. Is securities likely to be the hot button issue in the federal Supreme Court like it was in the 1930s when Puka, in the 1940s when Puka was a front page issue when cases were raised involving Public Utilities Holding Company Act? I think not, because justices are picked on a different basis today, right? They are almost uniformly Court of Appeals judges who have some track record, so we know that they're not terribly controversial. Not many of them have either agency experience. Certainly we don't have any politicians being appointed to the Supreme Court. The SEC is no longer the frontline agency that it was in the 1930s. It was a transformative, disruptive force then. Now it is one cog in a much bigger administrative state. And there's no Powell, and there's unlikely to be a Powell who would be interested in the securities laws on court today. The lawyerly response here, of course, is to say, on the other hand, yes, maybe it will. There are a number of justices who are very interested in administrative law and the administrative state. And Jarchese last term, involving the Seventh Amendment, showed some interest in reining in on administrative tribunals. Loeber-Bright may augur more scrutiny of agencies like the SEC. Maybe the climate disclosure rule will be the opportunity for the first important post-Loeber-Bright smackdown of an administrative agency. Eric.
So thanks, Adam. Definitely thanks to the division for co-hosting. I think this is probably around year 12 as a co-host, and I actually was involved in the conference prior to that. Absolutely wonderful to work with the division, the regulators who really care, and that's incredible. And also, as somebody who teaches securities law, gives a lot of insight in regard to what's actually going on at the state level, and Andrea is definitely a leader in that space. So very pleased, and pleased to have you here, Case. 51st year of the conference. The first 50 were in Columbus, but bring it to Cleveland. And happy to have all of you involved in that, and hopefully you'll be here for the next 50 years in terms of attendance. So in terms of what I'm going to talk about, I'm going to be a bit less ambitious than Adam and talk specifically about the Roberts Court and specifically look at that issue of the random walk and try and answer the question of how random it is, whether or not, in fact, there is some method to the madness, which I think there is, or just simply a tale of sound and fury, signifying nothing to paraphrase Shakespeare, leaving out the idiot part because I'm not going to the Supreme Court justices idiots.
Fine, John.
I didn't say it, so you so I will put plug in for Adam and Bob's book. Wonderful text, really worth the read. Some of the chapters I really think are page turners, including material on insider trading. There's some wonderful statistical analysis at the end, and if you love history, that permeates the text. The reason that I'm so enamored with the book, despite the fact that it's well written, is that it's really hard to get an inside view into the Supreme Court and understand what they're doing, especially because justices often won't publish their papers until long after they're dead. So as a result, archival research is really hard to do. Getting insights can be difficult. Maybe do a little bit better with that in terms of modern communication. But even in terms of getting a view of what it looks like for the Supreme Court to be in session, this is actually one of two known photographs of this. This one from 1932 by a German photographer named Eric Solomon, who was hired by Fortune to shoot images of America during a tour. And he actually did that by inserting a camera into a sling and taking this picture. The other one, this picture 5 years later in 1937, basically someone managed to smuggle in a camera in a purse and took this picture of the court for Time magazine. So I guess the message is, if you want a picture or figure out a way to hide your phone in a creative way. So in terms of what I hope to accomplish with the remainder of the time, I'm going to start off and talk about the courts of the Court of Courts, which seems repetitive, but I think actually makes sense in terms of thinking about the various courts that we've had in regard to the Supreme Court that are known by Chief Justices. I'm going to offer a new analogy for the Roberts Court in securities regulation, which is actually not that new. It's one that I've coined. It's been around for a little bit. That originally I put forward in an article in the Case Western Reserve Law Review, which obviously we published. And then finally, I'm going to talk about various implications of that analogy. So, the courts of the Court of Courts. It's very curious that, in fact, we actually know the Supreme Court by Chief Justices. The reason for that is just because a new Chief Justice is appointed doesn't mean that the disposition of the court necessarily changes. Certainly, that person's going to be influential in terms of discussions of the law, may have some role in assigning who writes a particular case, but actually making those breaks. It's curious to do that. And there have been 7 Chief Justices basically since the enactment of the 1933 and 1934 Act. We have Chief Justice Charles Hughes, Chief Justice Harlan Stone, Chief Justice Fred Vinson, Chief Justice Earl Warren, Chief Justice Warren Burger, and Chief Justice William Rehnquist. And then finally we arrive at our current Chief Justice, who actually took his seat on September 29, 2005, Chief Justice John Roberts. In terms of thinking about the Roberts Court, you also have a ship of Theseus problem. This is a picture of the Supreme Court, and this is dated from March 3rd, 2006. Taking note of the justices there. this is the current Supreme Court. If it looks a little bit different, the answer is yes, because literally the only two justices who are the same in these two pictures, you have Justice Thomas and then you have Chief Justice Roberts. So 7 different justices. That being said, if you look across the history of the Roberts Court, there are certain trends. Probably those trends actually began during the Rehnquist Court, as Adam very correctly notes. But for purposes of this analysis, simply going to take a look at the Roberts Court. In terms of thinking about the Roberts Court, relatively limited literature, great articles by Adam, piece by John Coates, piece by Isaac Hickson, a couple of pieces by this joker named Chafee, who I know pretty well. I apparently forgot to write my name on the second one there. Unlike me not to take credit for something when I have an opportunity to, but apologies for that typo. Ultimately, in terms of thinking about this, you look at the cases, and Adam had to do a lot of reading when he got to the Roberts Court in terms of reading all of the opinions. It would seem like the Supreme Court really, really loves securities regulation. They take 2 cases per term. I'm burning through a lot of slides here. They seem to keep on taking cases. They keep on taking cases, and they keep on taking cases. Roughly 2 per term, and the docket is getting smaller. So the question is, well, why are they doing this? Is it because they want to make a meaningful difference in regard to this law? At least part of it is I think that lots of money actually ends up spilling into this particular area. And there are also a couple of cases that were actually dismissed by the judgment that are listed. And cases currently before the court, as Dean Rose mentioned at the beginning of this. In fact, I don't think that it's actually that they are particularly interested in securities regulation, other than the fact that I think that they want to create stability in regard to it. And if you look at the different opinions that have been issued by the court, they really fall into 4 broad categories. First off, unrealized landmark opinions. Second, tinkering with core substantive issues of securities law. Third, securities litigation procedure. And then 4th, cases at the outer limits of securities regulation. And all of the opinions issued by the Roberts Court and the matters that they've granted cert on can be grouped into these categories. Some actually straddle the line between multiple categories. If you're thinking about procedure, where you fit Morrison, for example, is that an unrealized landmark opinion, or the alternative is a procedure-based opinion talking about the extraterritorial application of securities law. But what we see is a court trying to, for one of a better way of putting it, be relatively boring. Meaning that we have the Stonebridge opinion. Ultimately there we see this theory of scheme liability that could have remade things in regard to thinking about the implied private right of action. We knew we didn't have an abetting liability, but maybe we would have had scheme liability. The court says, no, we're not doing that. The Morrison opinion, which you actually might be able to debate whether or not it's a landmark opinion, in the sense that what it said is, well, despite the fact we have all this case law that says there's extraterritorial application of federal securities laws, no, we're not doing that. Ultimately, with that, they challenged Congress, and obviously with Dodd-Frank, the rules, the laws changed on that, but it wasn't the Supreme Court who made the change. With Halliburton too, where they were given the opportunity to do away with basically the fraud on the market theory, the presumption of reliance, which would have made it impossible to bring class actions. And what they said is, no, we're not doing that. And we have the Solomon case, which Adam talked about, where essentially they were given the opportunity to remake insider trading regulation. And they said, no, we're not doing that. Or maybe even more precisely, ditto, meaning that what they said is, we already said all this stuff in dirt, we're going to do that. So, nothing's going to change here. There's nothing to see here. The other cases, we see tinkering with core substantive issues of securities regulation, various questions often about the implied private right of action. For sake of time, I won't run through all of those, but there's a bunch of those cases. In addition to that, there are a bunch of different securities litigation procedure cases, which is not surprising. I mean, the Roberts Court, very interested in procedure. We also have some relatively new statutes, the PLSRA, that ultimately were figuring out what the Supreme Court was figuring out what those meant. So as a result of those, lots and lots of cases in that area. And then we have the cases that are at the outer limits of securities regulation, where there's a glimmer of hope that the court is in fact going to do something exciting. Notably, in regard to these cases, a bunch of cases about whistleblowers, but you also have a bunch of different cases about administrative law, including most recently Jarkesi. There are a million ways to pronounce it. I'm not entirely sure at this point because I've heard so many so regularly, but we'll go with Jarkesi. I believe is how I pronounced it today. I'm going to
Completely made that up.
That's how I keep my classes, so I have absolute respect for that. So with the Jarkesi case, administrative law, basically the court said we're going to do away with some of the existing ways that administrative law exists. So we have this taxonomy: unrealized landmark opinions, tinkering with core substantive issues of securities regulation, securities litigation procedure, the outer limits of securities regulation. We know where the movement's probably going to be. It's going to be the outer limits of securities regulation, where they're using securities law as an opportunity to reimagine what administrative law looks like. The climate disclosure rule comes up. We're probably going to see some sort of major change, some sort of major announcement about SEC power there. As a result of that, if you're trying to think about what the Roberts Court is doing, are they listing around back and forth in this random walk? Yes, they are. Random restrictive opinions, great way to think about it. But my view is that another way to think about this, and securities regulation loves analogies. Think about that judicial oak that grew from the legislative acorn that Rehnquist talked about, Chief Justice Rehnquist talked about in blue chip stamps, and definitely Stevens paid homage to Judge Friendly in the Second Circuit by calling him the master arborist of that particular treaty. My view is that the Supreme Court is acting as a museum curator. And if you're wondering, that is a picture of Starry Night that I took on Friday night in MoMA in New York because I was trying to send my mom the worst picture of a Van Gogh that I could actually make. I gave this presentation during COVID. I found that picture horrifying. It's been long enough afterwards that a massive group of people in front of the painting I'm no longer worried about, so now I find it funny again. And maybe you don't, but shouldn't this be about pleasing me at least in a little bit? And I did get closer to the painting later in the night. The museum curator analogy, I think, works pretty well. Basically, securities law in the Supreme Court has become about maintaining historical relics, basically doing some minor restoration work in terms of tinkering with core substantive issues, making determinations about access, so securities litigation procedures, the way that a museum curator, in fact, will set the hours to the museum, and then having in some special exhibitions to draw in people, which are those cases at the periphery of securities law. Question then is, what exactly does that, in fact, mean? Select to move. And we can explore the reasons of that. I'm a technology chiller, despite the fact I write about it, so I probably killed our machine. I think there are a bunch of different reasons that you can posit here as to what Chief Justice Roberts is doing. And we'll probably have to wait until we get access to his files in a long, long time from now to figure out which one is true. Part of it is I think that it's probably in part the temperament of the court, meaning one of modesty. This notion that Chief Justice Roberts talked about during his confirmation hearing of simply just calling balls and strikes. You may go to judicial philosophy. We talked about earlier about the court being more textualist. Justice Kagan at Justice Scalia's funeral talked about the court taking a move towards textualism, so it's probably a bit of that. I do think expertise or lack thereof figures in a bit in the sense that we don't have anybody on the court like a Powell or a Douglas who's really excited about securities regulation issues. I'm not sure why. I mean, when Andrea mentioned that it wasn't the space NASA, it wasn't the exciting one, I thought, of course it is. It's the securities one. It might be.
Why we're friends, Eric.
I'm amongst my friends. Theories of regulation, meaning that business people do not like uncertainty, and as a result of that, the court, in fact, may be trying to make it so that we don't see massive shifts in regard to securities law. That may be intentional. And in addition to that, we should, in fact, also be thinking about the implications of this particular analogy. Ultimately, there was this historical view that the Second Circuit was the mother court in regard to securities law. Certainly in regard to that, that is no longer true. Meaning if you look at a lot of the cases in which the Supreme Court has examined the innovations of the Second Circuit, they've said, no, we're not going to do that. In fact, being viewed as innovative by the Second Circuit can be the kiss of death if you are trying to, in fact, get something changed by the Supreme Court in regard to its case law. Beyond that, it means there's going to be an entrenchment of well-constructed and ill-constructed case law, meaning that despite the fact that we probably do need a coherent and cohesive system of insider trading regulation, commonly that ends up being proposed in Congress, but never passes. We're not likely to see that anytime soon. So if you like securities law, you're probably pretty happy with what the Roberts Court's doing. If you hate it, you are probably pretty sad. If you're somewhere in the middle, well, you're probably somewhere in the middle. In addition to that, you do have the argument that, in fact, where the Roberts Court is basically reinforcing legitimacy of the court. If you like separation of powers, the Roberts Court really is not taking on the role of being a super legislature in the space. That increases the role of the Congress in terms of regulation and the SEC. That being said, with the Loper Bright opinion, there's a question of how much the SEC in fact can do. You also, in terms of implication, can draw the fact that this may just be the end of history in regard to securities law. Maybe we're headed towards a very boring time period where securities law professors will still get really excited about minor changes, because I always do, but we won't see a major shift here. And beyond that, if you have thought that the Roberts Court has a pro-business bias, there's probably not one in this space. Based on my analogy and Adam's statistical analysis, that just doesn't seem to be the case in the area of securities law. Expansive, restrictive, they're equally balanced. The court just seems to be maintaining what's already happened. Question then is, well, what's the path forward? Will we see any major changes? Probably not. We could end up with some new statute like the PLSRA that the court has to interpret. There may be some major changes that go along with administrative law. You could have a new justice like William Douglas or Powell appointed to the court. That could actually happen, but likely what we have is business as usual. But with that, I think I'll stop there and say thanks so much for listening.
Thank you, gentlemen. Give us just a moment. We'll get set up for our final panel.
Thank you.
I wanted to say hi. I'm George.
Oh, I'm sorry.
When you guys on not everybody left. It's good. This is gonna be fun. This is gonna be fun.
I promise this will be the live.
The spirit.
We will be live.
I guess. That means one plus.
It's gonna have.
You can name it, you can name it. I'll take the best one of the next few all days.
See you out there for sure.
Okay, well, I am privileged.
I've been doing this, so I don't know.
Ty is the president and the CEO of the Healthy Markets Association, an investor-focused, not-for-profit organization focused on increasing transparency and reducing conflicts in the capital markets. He has a vast amount of experience in the financial markets, including a stint in the U.S. Senate, working for Senator Carl Levin, where he was the lead author of the Volcker Rule and has been involved in regulatory issues in the financial and securities world ever since. And Heather is a principal in the financial services practice at Mindset, a bipartisan public policy firm in Washington, D.C. Prior to joining Mindset, she worked for more than 15 years on federal economic policy, including on Dodd-Frank, the Jobs Act, and then advising Chair Gensler on many of the marquee policy initiatives of the SEC, such as the Climate Disclosure Rule, the Mutual Funds Names Rule, and Cyber Risk Disclosure, just to name a few. Prior to the SEC, Heather was the Director of Capital Markets Policy at the AFL-CIO, the head of the UN policy at the UN Principles for Responsible Investment, and a Senior Fellow at Americans for Financial Reform. Please join me in welcoming Ty and Heather.
It was, thanks. I wanted to take just a couple of seconds because I know it's the last panel and we're before you hop out on a Friday. But a couple of things. One, I'm kind of excited to be sitting next to Heather. She was a policy director for Chair Gensler. So the giant everything agenda is her fault. All of it. Had nothing to do with that guy who was a partner for 18 years at Goldman Sachs and then went to the Treasury and then the CFTC and screwed things up in derivatives world. It's her. It's exclusively her. I wanted to, by the way, and this did come through. So I started my career doing pump and dump cases as a special master in defense counsel. And then ended up doing broker dealer and investment advisory work in New York, as every good Western New Yorker does after graduating from law school. I'm also excited to say I'm back in this building after taking the LSAT. Was the last time I was in this building, almost exactly 25 years to the day, pretty close. So it's been a while. But I did want to say, so I come at this from an enforcement defense counsel, then decided it was more fun to send subpoenas to my former clients. So worked in the permanent subcommittee on investigations as well as in the policy role. So we worked on the investigation of the causes of the financial crisis, which is how I met Chair Gensler and Heather. And then we also worked our way through things like Dodd-Frank Act, the Volcker Rule you mentioned, but also things like investment advisor registration, the investor advocate office at the SEC, obviously Title VII, which was another big area for all of us. And then moving on to things like the Stop Trading on Congressional Knowledge Act, which unfortunately I also have to write op-eds on every now and again saying, yes, when we wrote it, we knew this was a failure, we had to do better. But those types of things. And so when I left government after mercifully only 1 year as chief of staff for one of the SEC commissioners, we started Healthy Markets to do institutional investors. And one of the things we're going to talk about is the accredited investor. I just want to start by saying some of the most sophisticated investors in the world are not, right? So when we talk about things and we say, hey, you know, they're in charge of a $100 billion, $800 billion pension fund or a $500 million fund, they can get whatever they want. The answer is no, they can't. And we'll explain some of this. But there's also massive, massive information asymmetries that it persists in the private markets, and we'll get into that more. But the first thing I wanted to do, because I don't think it for folks who don't know, this is probably one of the most influential policy people in capital markets regulation you can have. And of the 30 people in the country, 15 or so Republicans, 15 or so Democrats, I feel honored to be here with her because she's going to be one of the people who's shaping, frankly, not just what this administration did at the SEC, but with any kind of luck, the next one. And if not, then advising the minority commissioners on why everything goes wrong.
Well, thank you, Todd. I'm flattered.
But
And thank you all for having us here. This is fun.
So we're gonna be talking about the definition of accredited investor. And this deals with a few small issues in our markets, things like the role of government, the underlying role of the market, the usefulness of disclosure and the ability and leverage and desires of investors to make changes. So let's just start very, very general. The concept of accredited investor has been a staple in securities laws for 40 years. What was it designed to do and has it accomplished its goals?
is that even still legal? I mean, I asked the question because I thought I just heard about deference to the agencies, and last I checked, the federal securities laws regulated public offerings as securities. And if I think privately, among maybe amongst us, if I were to raise an unlimited amount of money from an unlimited number of investors, does that sound public to you in the plain meaning of the statute? So when we start this question, we had a really good conversation earlier about strict textualism, right? And the increasing focus on that. And we heard about how, gee, in the 70s and 80s, there was a pulling back of the deference, maybe a little bit more recently all of a sudden. I would argue the reason why we're seeing a pullback of the deference is in one scenario, deference was given to deregulation. Chevron was written as a deference to the agency to not regulate. That was the purpose of the decision. That's the purpose of the decisions that followed. Now we're seeing a shift in deference being used to justify agency imposition of burdens of regulation. There's going to be a different response to that. And so when we start just a pure discussion of accredited investor, I would say, well, what's the textual basis for the original authorization? Let's just go back to Reg D. How does Reg D even exist? Because it is defining public not based on anything that the statute says, right? And by the way, when we tie it, I don't see in the statute any reference to income from the 33 Act as originally drafted. So when the commission did this, they were implementing what they thought was an interpretation of the Supreme Court opinion, right? And forgive me, I'm sorry, Heather. I'm just I wonder I would filibuster. But let's think about it for a moment, right? Like Reg D, when we started, it focuses on like who the offeree is, right? And we built this system, the accredited investor system, about generally wealth and income, and now we might say sophistication or what have you. But if you read that opinion, right? Like Ralston Purina, 1953. So I think it was in the, what was it, the dead period or whatever we just heard, right? The post-war dead period. Nobody's doing anything. But 1953, there is Ralston Purina. And Ralston Purina was, the Supreme Court says it's a public offering. Now, this was offered to a handful of employees. I think it was 5, right? A handful of employees. And they said employees are every bit as much the public as any of their neighbors. That's a direct quote, right? So they said an offering to 5 employees or something like that was an offering to the public. That doesn't sound like the way we look at things right now, does it? I mean, you're all practitioners or not, but many of you are. So that's one thing. At the same time, there's another part of that opinion. By the way, not the part on sophistication that everybody quotes, there's another one where it says, once it is seen that the question on the exemption turns on the knowledge of the offerees, right? Wait, hang on a minute. Once it is seen that the question on the exemption turns on the knowledge of the offerees, then the issuer's motives, laudable as though they may be, fall into irrelevance. We don't hear that paragraph cited much. It's the very last paragraph. It's the one right before they said reversed. It's the last thing they wrote. Shouldn't we remember that? So as I sort of think about how we approach accredited investor, I actually tend to agree with Patrick McHenry from the Republican who's done a number of deregulatory bills in the name of capital formation. In 2019, there's a hearing. And there's a number of witnesses and they're like, God, this accredited investor thing is really stupid. And he says, isn't it dumb that we measure people's sophistication and gatekeep access to these things based on how much money they have and how what their income is? And I was like, damn right, I agree. The problem is it's the commission created this entirely made up thing to basically say like, we probably shouldn't care about people with a lot of money. And we've kind of boxed ourselves into that, but we've ignored the other part of this, which is you cannot make an informed investment decision without the information part. And so if we're going to start expanding or tying, if we're going to start expanding access to the private markets, one of the things we have to think about is like, what information are we going to have? Because I can tell you, I represent some of the theoretically most sophisticated financial institutions in the world. And they have very different levels of information amongst themselves, amongst individual investments, amongst investment advisor relationships. And if we think anybody who's got a Robinhood account is going to be getting the same type of access, the answer is hell no. So I want to pause for a moment and say, like, let's think about what we're doing from a, do you have the money? Do you have the sophistication? But do you have the information? All right.
So as usual, I agree with like 95% of what Kai said. The piece I would sort of disagree with you on is that like there's lots of case law, yes. One of the things that happens when you work in policy in Washington for a really long time is that you start to look at the world and you say, okay, this might be the correct legal answer, but this is the reality that we live in. And this is what can actually happen given the decision makers who are empowered at this moment in time. And the reality that we live in is that we've now got 40 plus years of precedent living under a regulatory framework that includes an accredited investor definition. So what do we do with that now? And I would say $1 million is still a whole heck of a lot of money to most people, to like 99% of the population. That's not a real number. You can look at the statistics. I don't know exactly how many investors have $1 million, but I bet you could find it pretty quickly on Google. And he's right. That's not a really smart way to figure out who has the sophistication to make an informed investment decision and look at what information's available. Look and see, like, what are they telling me about this investment? And maybe you don't need an entire audited financial report in order to make an informed investment decision. I mean, raise your hand if you have read every page of every prospectus of the mutual funds or the investment funds that are in your 401k. Okay, I was the policy director at the SEC for 3 years and I have not. And I would venture to guess that the vast majority of people in this country do not. My very first job out of law school, you went there, I gotta go there now too, was preparing the filings that mutual fund companies made to the Securities and Exchange Commission, preparing the prospectuses. And so when I would go home and my parents' friends would ask me at synagogue what I did for a living, I would say, you know the mailings you get from your mutual funds and you throw them away? And they would say, yes. And I'd say, well, I write those. So people aren't reading all of the pages that we're giving them. And so we've got to think about how do we really decide who's sophisticated? How do we look? And the commission has gone in this direction a little bit in recent years. In 2020, there were new regulations and we started to think about, are there additional ways we can think about sophistication in the current marketplace? And I think that it makes sense to further go down that route, to think about, it's not an asset test, right? We always talk about, at the SEC, the retired dentist. There are lots of people out there that have lots of money and maybe you're maybe not sophisticated, and I have to make my case connection now. My dad went to Case Western for dental school many years ago and is now a retired dentist. So I think we need to think creatively about how we inform investors, how we allow them to take risks and not take risks and have control over their financial futures without burdening them with lots of pages of information that they're not going to read.
Well, it's an interesting time for this conversation because just this week, a group of lawmakers proposed legislation that would create a sophisticated investor test. And so whenever we have this conversation, one of two things comes about. One is an argument, something like the accredited investor definition is way outdated. It was passed in 1982. It hasn't been updated in 40 years. And if we did that for inflation, it would be worth X, Y, Z. And the second line of argument that I often hear is, well, why is the government stopping people, anybody, from getting in the private market opportunities, some of which can create generational wealth? Tyler, what would you say to the second?
Couple of things. So let's start with, I hate to go back to 33 Act, but I will. So 33 Act, why do we do it? We want people to have a baseline level of information. That's the point, right? Like we want people to. So the idea is we want the investment public to have a baseline information. What is really interesting about our markets now is because the private markets have gotten so large, right? And because of the nature of capital raising, the vast majority of growth capital is now done before IPO, right? So that is where the sort of, for lack of better phrase, explosive growth is. One of the really big challenges is if you just open the door and say everybody, let's remove the accredited investor. Everybody's an accredited investor. We'll call that there are folks on the Hill who would argue for that. Like anybody can be an accredited investor. The question would then quickly turn on to like, what do you think they're going to do? Like, what do we think their returns look like, right? Because the answer is really simple. Like, if the idea is the most sophisticated investors in the world end up dumping money into FTX or Theranos or WeWork or God knows how many other billion-dollar frauds we now have to have. What do we think? Again, sorry to pick on your dad, but the dentist or the retired dentist what do we think his access is going to be to those opportunities? You know, Elizabeth DeFonte at that same hearing in 2019 said they're extraordinarily remote, and there's reason to believe that, right? If you talk to the VC community, they're not thinking, hey, I'm going to raise a whole bunch of money from a ton of investors because I really like dealing with lots of little investors. They're fun. That's not what they want to do, right? If they can go to one-stop shop and get a couple of $1 billion or a couple $100 million, they'll go to the one investor. And it's the folks that have passed on that, or alternatively, the one investor who is trying to offload. So when we look at the lobbying, for example, when we look at those who are lobbying for these changes, right, most aggressively, it tends to be the firms who are actually looking to offload those investments. That's why we're seeing, that's why we're seeing a huge uptick in not just private market activity from an initial issuance, but secondary market activity. That's why we're seeing the massive uptick on payments in kind in the debt markets, right? We're seeing a whole lot of folks who are trying to say, like, look, I can no longer unload this on another sophisticated investor at the valuation I've been carrying it. Any ideas, guys? Right? And so we're seeing rolling over to secondary offerings to new fund investors advised by the same advisor. Or we're seeing swapped investments between private fund advisor, and locking the valuations at the same levels. When we start to see those things, we have to recognize that look, if you're talking about a $2,500 minimum, we're talking about retail here. These aren't accredited by saying sophisticated. $2,500 is not a lot. That's not $1 million. That's $2,500.
I mean, I hear everything. You're talking about sophisticated investor to sophisticated investor by any threshold, by any threshold that anyone could conceive of, engaging in what may be poorly informed investment decisions. That is not what the accredited investor definition is about. And when you are talking about these big time VC firms who are trying to offload, that is at like a scale that I just think is unrealistic to execute with small mom and pop investors. So I think when you start to talk about what do you actually get if you expand the accredited investor, or if you if you lower the accredited investor definition, if you make it more difficult. I mean, I don't think that all of these small startups or Ponzi schemes are calling Sullivan and Cromwell saying like, what securities regulation do I need to follow? I think these people, the people who you're worried about, the mom and pop pump and dump, are not worried about the securities regulation. They're just trying to steal from people.
Well, yeah,
And so what you end up doing is you make it more difficult for the legitimate businesses who want to be able to provide some basic financial information without the full wrath of the SEC coming down on them, to be able to raise small amounts of capital from their friends and neighbors in order to start a business.
so you made a compelling case for crowdfunding. But that's just, so one, that's delightful. Full disclosure, I was involved in the drafting. That was the only part that the Senate Democrats had a role in, was that part of the Jobs Act. But one of the things I would say immediately is, when we look at Reg D, it says, we're looking at a credit investor in 506, we're looking at a credit investor. But the other part of it is no information. Now, you just said making an informed investment decision. I would say, and you repeatedly, and I agree with this, that like there should be something to make an informed investment decision. There is nothing.
No,
There is.
yeah, you're assuming that these people, that a sophisticated, that an individual is going to go and invest in a company and not ask any questions about the financials. There is a
You need to
difference.
meet my dad.
Okay, but you know what, I'm sorry, Ty, I'm sorry, but like, if your dad is gonna do that, I don't think an accredited investor definition helps him.
Agree.
I think that if your dad is gonna invest with somebody and ask no questions, then the scammer who's running
Mhm.
nothing, the scammer who has a PowerPoint presentation and some, PowerPoint, right? Like,
Mhm.
PowerPoint presentation and some Excel spreadsheets could get your dad to invest. And I don't think that I don't think the accredited investor, changing the accredited investor definition helps. I think that if anything, it gives Andrea another claim to make when she catches the small-time fraudster who's engaged in outright theft. But the guy's already stolen and committed a bunch of other crimes, so what do you really get with
So
that?
the question is not so much the fraudster, right? Like the question is efficient allocation of capital, right? Like you can, setting aside Supreme Court cases about like what fraud means and private rights of recovery, right? Because I think that's also a big thing here, right? Because retail investors have pretty robust ability to try to recover for fraud. There's a whole bar dedicated to that activity. And in the private markets, you don't see it, and they may end up here in state regulator land, or they may end up in an abyss, right? So the question, so fraud, set aside, it's
Part of the reason the securities bar is there is because of the massive amounts of money they stand, like the lawyers stand to make from bringing those claims, which I just don't think is gonna be the case with these smaller businesses.
depends, right?
It depends on the scale of the fraud.
You've lost. Sorry, we've digressed.
So, I mean, I think,
This is time. We've done this a bit.
Every security bar.
It's probably.
so Heather, would you support something more akin to a sophistication test? Opens up the private markets to non-wealthy.
I think it would have to be well crafted. The devil is always in the details, but I think if you could genuinely assess an individual's sophistication, then that could give you a sense of whether they were, in a position to be able to make an investment decision and be able to negotiate on their own for the types of disclosures that are necessary in order to make that informed decision.
Because retail is definitely going to be negotiating one-on-one with this entity.
If
I'm
you
sure
can't-
that.
But if you can't satisfy the sophistication test.
Well, you may be able to satisfy a sophistication test and still lack the ability to negotiate
But
and still.
To walk away from the transaction.
Because that's usually, and this is one of those, and this is the ultimate challenge, right? Like, if you are someone who's going to say, hey, I want to invest in this thing, the question is, am I going to walk away because they don't answer my question? Or, gee, am I going to go into it because, I'll take it. One of the things that I would say is like, hey, accredited investor suggests that there's some sort of, I don't know, accreditation. And until very recently, there hasn't been. It's how much you make. And by the way, we're not even going to verify how much you make. Right? Like, by the way, we've got this wonderful opportunity on our website. Tell us, do you make enough money to invest in it? If so, great, here it is, right? That's an interesting way to go about what I would call an accreditation process. I would think that that would have something. Now, I certainly agree that a level of sophistication would be one thing, and we did that. Obviously, Series 7, Series 65, you could say, like that actually might make sense. Maybe even a CFA or something like that. Those things might make sense. But I would also argue, and again, not to steal from another court case that wasn't cited earlier, but I forgot the exact phrasing, but something along the lines of like, hey, investors need information, much like an artist needs paints and a brush, right? Because no matter how good of a painter you are, if you don't have paints and a brush, you ain't painting anything. And so if we think about information that way, I would say like, hey, accredited investor, A, maybe you have some sophistication. B, maybe you have some. C, maybe you have some information. Or alternatively, maybe you make sure when we talk about fairness or fraud and what's disclosure. Again, fraud's a big word and it's being redefined by the Supreme Court a little bit in the private context as we speak. But let's just say for a minute, hey, one of my members, a large institutional investor, does want to offload to somebody else. What do they have to disclose to that somebody else? What if their limited partner committee gives them information that the potential purchaser doesn't have, right? What's their duty to disclose? Right now, it doesn't appear to exist. So in that context, from an enforcement perspective, is there fraud? I would argue probably not right now. But do we think that that's okay? And by the way, do we think that that's okay if they're doing that maybe to a fund that is exclusively retail investors? Do we think that's a 40 Act fund, say, or maybe just a group of retail investors? And I think we want to think about it in terms of the information to go along with the expertise, going back to 1953 and Ralston period, the knowledge of the offerees. And I also think, hey, something else that's come to light very recently, over the last couple of years, is redemption rights, right? And their human beings are fundamentally different than institutions. Humans get sick. Humans get hit by cars. Humans go to college. Humans buy houses. Humans get divorced, right? Institutions, my members, sort of plan. They know how many people work there. They know how many people are going in. They know how many people are going into retirement, right? Humans are different. And so here's the question. As we expand accredited investor definition, are we going to protect them from, hey, let's just say XYZ endowment or institutional investor, they can redeem and they can redeem based on information that they have that nobody else does, or they can sell it in the secondary market based on information nobody else does, but that other retail party can't? And they don't have that information and they don't have those redemption rights? I mean, those are the questions that I think Congress hasn't wrestled with. They've just said, man, make it easier. Credit investor, we're all the same. They're not, though.
But secondary market liquidity is not an accredited investor issue. Like that's an issue, and it's one that we need to think about. But I'm not sure how you get there from the accredited investor definition. And I think investors face liquidity risk in all sorts of investment products, and there's often a liquidity mismatch, and it's something that the commission has tried to manage and deal with over many crises over the recent 15 years or so. But like, I don't, what does the accredited investor definition have to do with?
Mutual fund, I get my easy. The who's going to be in buy it in the second market. Like if I go to NASDAQ second market, who's going to be able to purchase, right? So one of the things I think of when we think of retail, again, maybe I'll use a different family member this time. I'll use my nephew. My nephew looks at the stock market and he can trade instantaneously. And now because of his app, he can trade 24/7. He goes to the crypto markets. He, by the way, views that as gambling, not as investing, but that's a separate question. But he does say it's the app next to FanDuel from his perspective. It is, and he said it, the good news is I'll set that aside for a minute. So, but you know, when I think about my nephew, he's thinking, I can trade the crypto instantaneously 24/7. I can trade on my equities app 24/7. Third question, actually. Can he trade options? Yes. It's a little scary. There are options disclosure documents, and he should absolutely not have been authorized to have options account, but he does have an options account, and that's a third question. But those are all things he can trade in real time. And he believes if I go to trade it, I can buy and sell at plus or minus about what that price is. I'm not sure that he's prepared for thinking about, hey, if I buy this thing that maybe I can buy in the same platform on the same app, and I might be locked in. And by the way, I don't know what everyone else knows.
Does your nephew have $1 million?
No. But here's the question. If we're gonna make the accredited investor not a dollar-based thing, or alternatively a much lower dollar-based thing.
Not
But
arguing
here's
to
a
lower
question.
it, I'm arguing it.
To keep it, you wanna keep it at $1 million?
Not.
We're expanding it now. Congress is expanding, they're not keeping, they're
No,
expanding.
expand to include a genuine, like more sophistication.
Ah, if it's just that, then sure. What are we gonna hit by that? How many more investors do you think?
Do we know? I don't know that it makes a material difference.
Ah, there's a really good question. Do we know? Do we actually know? Do we have Form D, closing Form Ds, anyone?
Okay, but Ty, you're now making an argument that you would argue against in every other regulation that you support, which is about having to do a thorough economic analysis. And you know, the precise economic impact of a regulation before you finalize it. And I know it's convenient when you can argue against it on the other side, but there is never a precise way to estimate the impact of regulation, because any market participant is gonna have different economic impacts than their brother or their competitor or their niece or nephew or father, and there's no way any government actor can take in all of that information and summarize it in a way that really works for you and for each individual and represents your life experience.
Well, Heather, in your opening statement, you made this really great point about, the difference between the correct legal answer versus the reality of the situation. And the reality of the situation this last few years is that we have now started to see the emergence of sort of viral stocks and meme people trading because of the fear of missing out and things going viral on Reddit. And for those stocks, information is out there and people are acting irrationally. I mean, there's even filing where it says our stock price is, this is overvalued, this is insane. It says that in the filing. And people are still buying it.
While they're selling new shares to the market, God bless them.
Right.
AMC is just a wonderful case law experience.
So it raises the underlying question of, I mean, maybe at this point, the cat is out of the bag. The definition has been so watered down that maybe we start over. Maybe it's already gone. Maybe the effect of it, the protection of it is already gone. But in the age of meme stocks and people investing intentionally irrationally, what role should government have in protecting those people in sort of a paternalistic protection mode? Do you think?
Government has a responsibility to police the markets for fraud and abuse and to enforce the regulations that are on the books. And unfortunately, government, and this is part of the reason I have concerns about trying to pull more into the securities regulatory regime, is because the government is already so under-resourced when it comes to not just the securities space, but across the board. And I think, we don't have to go into detail about why that is.
Whatever.
But I do worry quite a bit about what we are expecting the regulators to do, and that representing that something is overseen, that some offering, some disclosure, some company is overseen by regulatory agencies when the regulators don't actually have the resources to police those markets effectively. creates comfort among market participants that shouldn't exist. And so that is part of the reason that I come to this argument the way that I have, and I'll admit that my views have evolved over time after being inside the commission and really appreciating the resource constraints that exist. I think as responsible actors, if we want the commission to do more, we have to think about how we make sure they have the capacity to do it, and those conversations have to go hand in hand.
Just to revisit one thing, and when we talk, I mean, because when we talk about private markets, the quick thing is to talk about fraud. But I also think, again, the securities laws were not just fraud. And if we go back and you read the House report for the 33 Act, it's, again, I'm paraphrasing, but it's whatever may be the causes of the depression in which we now sit. Not least among them is the wanton misdirection of capital of this nation, right? The wanton misdirection of capital. I don't know how you folks have approached the last like 6 years of the capital markets, but it kind of feels a little bit like wanton misdirection of capital of the resources of this great nation. I don't know, feels that way to me. And and certainly when we see the frauds, we see it, but in the non-frauds, we see it too, right? We see it in the valuations of real companies that take hundreds of millions or billions of dollars and go to zero, not because of fraud, but because they were just terrible ideas. And people didn't have enough information to say they were buying the hype. You know, when Peloton, before they're public and their CEO says, hey, on CNBC, you know, we're weirdly profitable. And then they file an S1 a couple years later and it's like, no, they weren't. I don't know how you were looking at that. But like, if you might have bought that in the secondary market, but that's not a case that can be brought under the federal securities laws in the same way it would have been post IPO. Because again, the S1 was a very different document than that CNBC interview.
But to John's point earlier, people are making really ridiculous investment decisions about public companies too.
Oh, and crypto. My nephew does crypto too. And there's no issue of disclosure most of the time, unless you're following the tweets of whoever's in charge.
You can't regulate against stupidity.
Yeah.
John, we do have a question.
Certainly. So I'm gonna make the comment and go back to your Reg D filing. I'm gonna leave your nephew out of this. And I'm gonna remind you that the person that sells the Reg D offering may be an investment advisor or broker dealer. When they take that sale from the broker dealer to the investor, they have to give the prospectus. There's your source of information. In addition, the investor has to fill out the subscription agreement where he's going to say he's an accredited investor. And we've talked about, you've filibustered whether the accredited investor number should be bigger, lower, include more people or less. And I'm going to say it's nice that there's a number, but technically the SEC, when they did their presentation, told us you got to do more because they've passed Reg BI. And you, as the broker dealer or the investment advisor, now have a due care requirement. And that due care requirement requires that you making the recommendation be able to document the basis for why you made that recommendation. So technically, your Reg D, the disclosures, and all the things that you made offering the private placement, layered on top of Reg BI, you have that information collectively together, or you as the investment advisor or the broker dealer should have that information. So as much as we want to filibuster whether the accredited investment number should be bigger, lower, raised for inflation, whatever, we, the broker dealer and investment advisor community, we have the requirement sitting on our desk saying, do this, because Reg BI, for every investor that's a retail investor, and that's an individual investor, accredited, non-accredited, it doesn't matter. You have to have the basis for making that recommendation, which means you've got to collect the information that says, we're going to do this.
Can I ask you a follow-up question on that?
Sure.
Who's the audience now?
So you have, let me give you an example. You have a client and they're retired and they don't have a pension, but they have a lifetime of accumulated savings. that makes them accredited, say they have over $1 million net worth. To what extent would you put them into an investment that they would qualify for as an accredited investor? But taking into account that they may have that an illiquid investment may be unsuitable for them, or that, that those dollars might not be equal.
So here's where you are in my view, and this is my opinion,
Yeah.
necessarily does not represent the broker dealers that I work for,
Understand.
is that under Reg BI, you have to have a basis for making that recommendation. In that process, you should know what their liquidity needs are, both now and in the term that you view that investment is going to live on in their portfolio. And so my question to you is, because Reg BI technically brings you in as a fiduciary, and if you are an investment advisor, you are a fiduciary, making that recommendation, me as your compliance person or your compliance officer or whatever would say, you've got to make, you have to understand this, and you have to understand your client's needs. And if you're not getting this right, I think you just made a lawyer's day, because under Reg BI and under everything else, the customer complaint is going to say you didn't do your job and everything to do right by your customer.
Well, yeah. Go ahead.
But I think you've raised actually a really important point, and one of the touch points in the policy. By the way, we're also going to take this back to Barb Roper, who is the godmother of Reg BI. So she will be thrilled to hear your reliance on it. But I think you've raised a really important question, which has come up a lot, which is, in the context of an accredited investor, maybe you can say, hey, well, instead of doing this, we'll do that, and maybe that is have an unknown number of retail be able to invest through an investment advisor, right? Like, that's another policy option, right? So to the extent that we can either change the investment company rules, or we can change actually the investment vehicle, you can structure it through something. Now, what's interesting about Reg BI is it's also one about making a recommendation, putting someone into an investment or recommending an investment. But it doesn't necessarily cover the unsolicited context, right? And one of the challenges we have in the private markets space is, if you're opening things up in a world to where, for lack of a better phrase, there is this equal access to it, there's going to be a significant influx of the, again, unsolicited orders and perhaps unsolicited information or lack of information, right? If we are doing for example, a venture exchange that I'll call it high-end retail, right? Because we're talking about individuals with a significant amount of wealth, then the question is, like, what do those rules look like? That's one of the bills we have in Congress right now.
I want to go back to to the comment that David made. I have to be careful because I use him as a consultant in a lot of my.
Speaking.
And he's right, but many Reg D offerings are not done through broker dealers. They're done directly by the issuer. But I can tell you this, because I work in that space a lot. 506B, I wouldn't touch a 506C with a barge pole. 506B, best practice. For one thing, Reg D is a safe harbor. We like safe harbors. It's very important for the certainty. Reg D also assumes an accredited investor that they are, whether they're sophisticated or not, they're sufficiently wealthy that they can withstand the risk of loss that a non-accredited might not. But most importantly, it's best practice and normal practice in Reg D 506 offerings to put in a subscription agreement that has a sophistication standard as well as the accredited. And we do that because if you don't qualify somehow for the safe harbor, you can still fall back on the private placement exemption in the statute. So I think a lot of what you're talking about is probably in the real world not as much of a problem as perhaps you're suggesting.
It's both, right? Like, that's exactly it. It's one of those things where you always end up bringing the enforcement cases, or you end up seeing the egregious things, right? Like, as policymakers, one of the things we wrestle with all the time is, it's after crises we see regulation, right? Like, there are a lot of folks who are speculating right now, private credit is going to be the next crisis, right? We just saw several regulators go on stage and make every news organization in the country saying, we're really nervous about private credit. What comes out of that? What does it look like? So it's absolutely true that there's not a lot of folks who are getting private offerings and securities based on zero information. The question, because right now we also have an awful lot of folks in this marketplace who are very sophisticated. The question becomes, if you are to make the existing world of private offerings look a lot more like the crypto world, or let's just call the retail public company trading apparatus, that's a different one. And that's what we're actually talking about, because that's what some of the legislation in Congress is doing. Oh, sorry.
So just full disclosure, so many years ago, I did my doctorate exactly on that topic, and people were shocked. Why are you focusing on private markets? Everybody only cares about public markets. And so I'm glad I'm in that niche space. And the reason I did it, I could see that our equity markets are going to change. And look at last year, more people raised money in private markets than public market. And we need, I think, a few more questions need to be raised here. First, the efficiency of our public markets. We have public markets that other countries are envious of. What's going to happen with the rise of our private markets, especially if we're not going to protect investors? That's one. Second, look at the players, because I've been following the players. Okay, and I think that was something that Tyler was trying to refer to with regards to offloading. It's not necessarily the VCs. It's the non-traditional investors that we have playing in these markets that are not asking for the same protections as a sophisticated player like a venture capitalist would be asking for. To me, there's several categories. You have the fools categories and the sophisticated money. And by the way, not just retail investors go in the fools category. Sometimes it's this wealthy institutional investors that are not going to ask for the same protections. They don't ask for monitoring. They actually many times count on hedge funds to do monitoring for them. And if you look at history, hedge funds have failed before. So why are you going to trust them to do it today? I don't know, but I write about this stuff. But the other thing is, as somebody that understands democratization and the need and the complaints, yes, my students are complaining about it. Sometimes I complain about it. I want to invest in certain assets that I'm not able to. But the problem is information. And yes, I'm also one of these people who will throw away whatever material you send to me. But I count on somebody with regards to public markets to do the auditing for me, right? And so I think if you are going to open up private markets, you need to provide those services, whether you do it through a closed-end funds, there's all kinds of solutions. So I would not, again, maybe as a professor, I have the privilege of looking at things as a systems perspective, but also our tax laws are not, by the way, adjusted for these. And Congress has tried to change our tax laws, did a miserable job doing that, okay? So we have securities, tax, and corporate, and even employees, because we don't protect employees, unfortunately. The Jobs Act, forget about the 5 employees in that case, right? Think about how many employees can invest now. Why? That's part of the reasons of why we saw the growth. And by the way, what do they do today? They use SPVs. And you can also, if you're sophisticated, bypass our securities laws. Thank you.
That, to me, the last point you made reinforces what I was saying earlier about sophisticated players will find ways around the securities regulation, and creating the impression for people that something is regulated when it's not, I think can be quite damaging.
Well, unless anybody has final comment or question, I just want to thank you. Excuse me. Thank you both. But
We kept you awake on a Friday afternoon. Thank you.
Thank you all for joining us. I want to give another shout out to all of the division staff who worked really hard on getting these amazing speakers. I think once again, just amazing speakers, diverse topics. It really It seems easy to do, but it really is not. It takes a full year for us to plan and orchestrate this event every year. So thank you. This way, David Beamel, Jeff Coleman, John Christ, Janice Hitzeman, Chris Ballard, and then everybody, please thank the folks out there in the hallway too. Friendliest bunch of registration people at any conference you'll ever want to meet. So please thank them on the way out. Please fill out the survey when we send it to you again. We want to make this better, and this is obviously Cleveland first for us. And we have had some kinks, we'll work them all out. If you want continuing education credits, make sure you have filled out the forms out there. We'll send an email out next week. That'll be your attestation, I think, and then we'll submit the hours for you. If you're one of those attorneys who likes to know the activity codes and have your own record, that code is 559963 for the attorneys seeking CLE. I'll repeat it one more time. 559963. And if you're our virtual attendees, you actually have a different code. Sorry, that's for the people in the room. People attending virtually, it's 559964. I'll say that one more time, 559964 for virtual attendees. Thanks again for coming. If you drove up, please travel safely. If you ever have any questions for us, we're very accessible at the Division of Securities. You can always reach out to me and I'd be happy to point you in the right direction. Thank you again for coming.